Hi, my name is David P Shapiro. I'm the owner and managing partner of the law office of David P Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. This video, I want to talk about whether or not there's an option to bail out if you or your child finds themselves up against the district attorney's office in juvenile court dealing with criminal charges, or a petition, as they refer to it in juvenile court. Well, in adult court, a lot of times you'll have cash bail set. So you'll get arrested and you'll have an opportunity to bail out between the time of your arrest and your first court date. You go to a bail bondsman, you pay 7 to 10% of whatever that cash bail amount is, and they put up the rest sort of as a collateral, as a surety that you're going to make your court appearances. Well, in juvenile court, you don't have that benefit as a minor, meaning there is no cash bail. So if you're detained in between court appearances, there's no way that you're going to be able to get out in between court appearances. But what your best bet is, you still have an opportunity to address your custody status, something known as a detention hearing. And that's where you as the minor or as the minor's parents will have an opportunity to address the court. Your son or your daughter's attorney will have an opportunity to address the court, as will the district attorney, to try and convince the judge why things should either stay exactly the same or there should be some sort of modification in status of the custody status of the minor. But it's not cash bail. That's not an option. There's not property bail. That's not an option. So it's very different than adult court in that regard. A lot of times the attorney is going to want to present a number of alternatives and ways that the juvenile or the minor could be basically kept in check if released home. Maybe they get released from juvenile hall into a program. Maybe they have some strict guidelines, curfews, things along those natures. All of those factors could go into the fact of what you're trying to argue to try and get your daughter or your son out of custody and into a place where they can start obviously moving forward with their life in a safe environment. And that's what their attorney should be looking at as well, a combination of circumstances that will ensure that they're on the pathway to rehabilitation if they in fact need that, and to cover all bases to make sure that everyone is comfortable, most importantly the judge, with the release conditions that your attorney is proposing. So to answer the question in short, can you bail out in juvenile court? Not by way of cash bail, not by way of property, but there are certainly release conditions that your attorney can and should be proposing to the court whenever appropriate. Hope you found this video helpful about juvenile court and the lack of cash bail. If you have any questions about juvenile matters at all, particularly in San Diego, my firm is just one phone call away, 619-295-3555. Again, David Shapiro from the law office of David P Shapiro, San Diego criminal defense attorney.